In this course, we're going to read many cases from different states to try to understand the nature of specific crimes. But underlying all the cases we read, we're examining foundational issues of different sources of law. Why does one state define burglary in a certain way? Why do states have different definitions of murder? So what I want to do in this quick segment is trace the kinds of law we're going to be covering in this course. In our discussion, we're going to cover 3 different sources of law. We're going to cover the English common law. We're then going to move to America and the modern statutory changes. And then we're going to examine what we call the Model Penal Code that originates from the American Law Institute. So let's start with the English common law. The roots of American criminal law can be found back in dusty England. I call it dusty England because that's my imagination about the way it looked back then. We're talking about the 1700s. So in the 1700s in England, the laws were judge-made. The judges crafted opinions, and in those opinions they defined the parameters of the law. They defined the law. So we call that body of law the English common law. In our discussions, many of them, we're going to start with that version of the crime. And then we're going to work to discuss the modern changes, because all of that law was brought to America by the colonists. For example, in a few weeks, we're going to learn that the crime of burglary required a certain definition back in England. And then we're going to compare that definition to what's commonly considered modernly around the country. So that's the English common law. The second type of law we're going to work with are modern statutes. What we're generally going to learn is the majority position around the country and sometimes focus on the minority view as well. How did that come about? Well, beginning in the 1800s, state legislatures started to take those judge-made rules from the English common law, and they developed laws of their own. They codified the rules into what we call statutes. Today, every state has a penal code that consists of every crime, every rule that's been criminalized. It also consists of the defenses that the defendant gets to offer. And what we're going to see is that they took their foundation from the English common law. So we're looking at the English common law and then comparing it to modern statutes. The third source of our laws comes from an institution called the American Law Institute, which developed something called the Model Penal Code. You're going to see something different called the Restatement of Torts in your torts class. You're going to see the Restatement of Contracts in your contracts class. All of these came out from the American Law Institute, or what we call the ALI. It is, in a sense, best practices on these areas of law. If you started with a clean slate, how might you approach the area of law? That was the task. In the 1950s and 60s, a group of judges, lawyers, and academicians were tasked with trying to create a blueprint for a penal code. That's because every state called the crimes differently. Every state used different definitions. And so the ALI said, what if we created a best practices penal code, a model penal code, so that the states could follow it if they wanted to? So they created a plan that states would follow in enacting their own legislation. They wanted to tackle this project to gain uniformity across the country so that every state would have similar penal codes. And that's called the Model Penal Code. It came out of this model plan. Some of the plan includes adherence to the British way, the English common law. Some were significant departures in language and in theory. It was intended to be a model for the states to follow. And in fact, when you look at penal codes from different states, you're going to see that part or all were actually adopted from the Model Penal Code. In essence, it's a template for crimes and their definitions. And indeed, many states have adopted the Model Penal Code. You, in fact, may live in a state that uses the Model Penal Code. Approximately 43 states have followed part or all of the code. We're going to be learning some sections from the Model Penal Code. In fact, our first case for discussion on actus reus that you will read shortly includes a review of the Model Penal Code section on what we define as an actus reus and what's not an actus reus. I was honored to be elected to the American Law Institute in 2012. I have to tell you, prior to joining this body, I thought that the Model Penal Code was crafted in a quiet back room by a few people. I taught the Model Penal Code, but I didn't really have a good sense of who the people were who drafted the code. The actual process couldn't be further from my imagination. That's not the truth. Instead, the Model Penal Code and all the other codes and all the other restatements are crafted by a huge body. It's a huge organization. It's filled with robust discussion and animated by the experience of the people in the room. Each year, they meet at an annual session to actually go through drafts, to discuss the different codes, the different restatements, and then to make changes, go back again for another round. Right now, we're tackling sexual crimes, which haven't been redrafted since the 1960s when the Model Penal Code first rolled out. And it's engendering quite a bit of controversy, both inside the annual meetings and actually on the outside of the annual meetings. It's still in the middle of the draft phase, not sure where that project's going to end up. So in sum, I've talked about 3 different sources of law. The English common law, which is the beginning or the source, the original source for all of our penal codes. Then the majority view from around the country, and in some situations the model penal code's view on particular topics. Need not worry about which law you have to follow. It'll become clear in the lectures, and I'll explain very clearly which law we're working on at that time.